The application was lodged with the court on 13 March 2014 under Article 33 of the Convention by the government of Ukraine. The Grand Chamber held a hearing on the admissibility on 11 September 2019, and following its deliberations on that day and on 28 September 2020, finally adopted its decision in full on 16 December 2020. I shall give a brief summary of the facts and read out the operative provisions of the decision. The summary of the facts is not a part of the decision and will not bind the court. For a more detailed explanation of the facts and a summary of the court's reasoning, I refer you to the press release which will be available at the conclusion of this hearing. The full text of the decision will also be available and may be consulted through the court's internet site. The case essentially concerns the applicant's government's allegations that the Russian Federation was responsible for an administrative practice in the Autonomous Republic of Crimea and the city of Sevastopol, integral parts of Ukraine, amounting to violations of numerous rights and freedoms protected by the Convention and protocols thereto, in particular Article 2, right to life, Article 3, prohibition of inhuman treatment and torture, Article 5, right to liberty and security, Article 6, right to a fair trial, Article 8, right to respect for private life, Article 9, freedom of religion, Article 10, freedom of expression, and Article 11, freedom of assembly. They also complain under Article 14, prohibition of discrimination, Article 1 of Protocol Number 1, protection of property, Article 2 of Protocol Number 1, right to education, and Article 2 of Protocol Number 4, freedom of movement. As illustrations of the alleged practice, the applicant government relied on alleged individual incidents that had occurred in Crimea and on the effects produced by general measures adopted in respect of Crimea during the period they had addressed in their applications, namely from 27 February 2014 until 26 August 2015. According to them, since 27 February 2014, the respondent state had exercised extraterritorial jurisdiction over Crimea, owing essentially to its military presence there and its support of both the local government and paramilitary forces, and accordingly it was held to be responsible for the administrative practice complained of. I will now read the operative part of the decision. The court, by a majority, operative point number 1, lifts the interim measure indicated to the parties on 13 March 2014 in relation to Crimea under Rule 39 of the Rules of Court. Operative point number 2 holds that the facts complained of by the applicant government fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention, and dismisses the respondent government's preliminary objection of incompatibility ratione loci with the provisions of the conventions and the protocols thereto in that regard. Operative point number 3 dismisses the respondent government's preliminary objection that the application lacks the requirements of a genuine application. Operative point number 4 declares that the rule of exhaustion of domestic remedies is not applicable in the circumstances of the case, and accordingly dismisses the respondent government's preliminary objection of non-exhaustion of domestic remedies. Operative point number 5 declares admissible, without prejudging the merits, the applicant government's complaints regarding the period under consideration concerning as follows. A, the alleged existence of an administrative practice of enforced disappearances and of a lack of an effective investigation into the alleged existence of such an administrative practice in violation of Article 2 of the Convention. B, the alleged existence of an administrative practice of ill treatment in violation of Article 3 of the Convention. C, the alleged existence of an administrative practice of unlawful detention in violation of Article 5 of the Convention. D, the alleged existence of an administrative practice of extending the Russian Federation's laws to Crimea and the resulting effect that as from 27 February 2014, the courts in Crimea could not be considered to have been established by law within the meaning of Article 6 of the Convention. E, the alleged existence of an administrative practice of unlawful automatic imposition of Russian citizenship regarding the system of opting out of Russian citizenship in violation of Article 8 of the Convention. F, the alleged existence of an administrative practice of arbitrary raids of private dwellings in violation of Article 8 of the Convention. G, the alleged existence of an administrative practice on account of the harassment and intimidation of religious leaders not conforming to the Russian Orthodox faith, arbitrary raids of places of worship, and confiscation of religious property in violation of Article 9 of the Convention. H, the alleged existence of an administrative practice of suppression of non-Russian media in violation of Article 10 of the Convention. I, the alleged existence of an administrative practice of prohibiting public gatherings and manifestations of support, as well as intimidation and arbitrary detention of organizers of demonstrations in violation of Article 11 of the Convention. J, the alleged existence of an administrative practice of expropriation without compensation of property from civilians and private enterprises in violation of Article 1 of Protocol Number 1 to the Convention. K, the alleged existence of an administrative practice of suppression of the Ukrainian language in schools and harassment of Ukrainian-speaking children at school in violation of Article 2 of Protocol Number 1 to the Convention. L, the alleged existence of an administrative practice of restricting the freedom of movement between Crimea and mainland Ukraine resulting from the de facto transformation by the respondent state of the administrative borderline into a state border between the Russian Federation and Ukraine in violation of Article 2 of Protocol Number 4 to the Convention. M, the alleged existence of an administrative practice targeting Crimean Tatars in violation of Article 14 of the Convention, taken in conjunction with Articles 8, 9, 10, and 11 of the Convention. N, the alleged existence of an administrative practice targeting Crimean Tatars in violation of Article 14 of the Convention, taken in conjunction with Article 2 of Protocol Number 4 to the Convention. Operative point number 6. Decides to give notice to the respondent government of the complaint about the alleged transfer of convicts to the territory of the Russian Federation in violation of Article 8 of the Convention, in accordance with Rule 51, Paragraph 1, read together with Rule 71, Paragraph 1 of the Rules of Court. Operative point number 7. Decides to join application number 38334/18 to the present case, in accordance with Rule 41, Paragraph 1, read together with Rule 71, Paragraph 1 of the Rules of Court, and to examine, exceptionally, the admissibility and merits of the complaints raised therein, together with the above-mentioned transfer of convicts complaint at the same time as the merit stage of the proceedings, in accordance with Article 29, Paragraph 2 of the Convention, and to invite the respondent government to submit their observations on the admissibility and merits of this part of the case, pursuant to Rules 51, Paragraph 3, and 58, Paragraph 1, read together with Rule 71, Paragraph 1. Operative point number 8. Declares the remainder of the application number 2958/14 inadmissible. This concludes this morning's hearing, and I accordingly declare it closed.
behind the self-defense units of Crimea. Of course, we had our servicemen. They were acting very correctly, but at the same time decisively and professionally.
Я пригласил в Кремль руководителей наших специальных служб, Министерства обороны. Поставил перед ними задачу. Но 23-го мы закончили около 7 часов утра. И расставаясь, я всем моим коллегам сказал, мы вынуждены начать работу по возврату Крыма в состав России.